I'm just, I'm, I'm fighting all this to try to respect what Dad wanted, and the farm was never to leave the family, absolutely. This is all, I have plenty of equity in other property to buy the farm. When Attorney Magnus locked me out of the place where I was living, we made life very difficult for the last 9 weeks. So I haven't been able to function very well. I mean, today I rode my bike here 30 miles because I don't currently have a working vehicle, because everything, my life is completely a mess. And Attorney Magnus, by locking me out without notice of the place where I was living on June 30th of this year, did something that most would regard as unlawful. So you're not allowed to just lock someone out of a place that they're legitimately living. Attorney Magnus tries to argue that.
You know what? You know what? You coming before me, and you've just tried to besmirch this man, and you were about to, if I hadn't cautioned you, take a shot at a colleague of mine on the bench in Oakland County. Why don't you just give me the merits of what it is instead of explaining to me all the bad things everybody in the world seems to be doing to you?
I have the means and assets to accomplish what Dad wanted, and the action.
Can I ask a question? If that's all true, why aren't you making an offer on the property?
I did, and they don't want to accept it because I have to sell my properties first. So, you know, people buy properties all the time where they have to sell their own residence first. So rather than work with me, that's why I'm so upset about everything, because people are not looking at the facts of the things, the equity that I have. It's just a matter, I could sell things as is today and get 280,000 for my West Bloomfield previous residence, or I could do a few things and get 350,000. Or I could do a lot of things and get 450,000. Next door house sold for 450 earlier this year. So people can put on me under how much pressure they want. Do they need me to do something today and sell the West Bloomfield house as is for 280? Or do they want me to get 350 for it so that I'll have more to buy, to put towards my offer on the farm? And I have other properties with significant equity also, and it's a similar story. So the personal representative, the estate doesn't have to be closed right away. I've made an offer that's higher than the offer that they want to accept. So there's, and it's just what my parents wanted, what I've always said was so essential. So why won't the personal representative or his lawyer work with me? Why did they change their mind? Why is it okay that he locked me out of the Farmington Hills house?
Okay, that's in Farmington Hills.
Yes, and I'm
welcome to Washtenaw. I don't have anything to do with Farmington Hills.
Right, but the one thing that you could do is to not allow this eviction to stand and just to wait for some additional probate court action. Because that's really what controls things, as you've said.
Oh, I don't think I said that entirely.
I'm sorry.
Okay, have you finished with your argument?
I mean, there are other cases where probate court was the one that made decisions about landlord-tenant issues where it's not really falling under the landlord-tenant law. Because of my interest in the property, the way as 50% advisee, title will ultimately, if it goes to me, will ultimately be backdated to the day of Dad's death. It's like title transfers at the time of death, subject to administration. So it's not a typical landlord-tenant case, and there's other case law that supports that. I just haven't had time to prepare things for you.
Procedural magic trick. A no contest plea isn't "I'm guilty," it's "I'm not fighting it." For sentencing, the court treats it like a guilty plea, but it can reduce collateral fallout in related civil stuff. Notice how counts 1 and 2 vanish once count 3 lands? That's classic charge bargaining. What would you trade to eliminate the heavier counts?
As I said, you've been given way more time than most individuals coming before this court.
Considering that I'm struggling with the probate court, so many filings, and the appellate court, and my unstable living situation, I would argue that I could be given a little more time.
Anything else?
Just think that the court is letting, as with so many things that happen with probate court involvement, the lawyers have sort of gone around the rules, and it's.
So now you're accusing the lawyers of going around the rules and the court's letting them.
Well, by signing the order of eviction when it really had.
Okay, well, let's get this clear. Sign the order of eviction, stayed it, had a hearing, gave you additional time once I found out that it really wasn't a residence and things hadn't been removed, and now we're here today. So if you want to talk procedurally, while it is unusual, if you want to talk procedurally and any detriment to you in that, it's not there.
Well, I have been harmed by the removal of my vehicles, and that was a part of the eviction proceeding. He removed the vehicles. The eviction server person required that the vehicles be towed before he would do his eviction and break into the house. And they did take things out of the house and damage some things. And I haven't analyzed what they damaged because I had been living there.
Well, before you told me they had.
What?
Before you told me they had.
I never said they hadn't damaged the house. They broke into the house and threw a bunch of things out on the lawn, and I put some things back on the porch. But they had.
Is there anything else you want to argue to this court?
I mean, there has been harm, and the harm came after they misrepresented to the court that they were entitled, that the PR and his lawyer were entitled to have the order of eviction signed by her.
Sir, there's a big difference between doing something and misrepresenting something. And, I'll be honest with you, I'll listen to you but I'm not going to allow you to just come in here and just smear everybody that seems to come in your path. Because that's all that you're doing.
This is the compliance gauntlet. Community corrections equals testing, check-ins, proof you're playing by the rules. Missteps and your bond can implode fast. Solid transition beat here.
Today's clean test buys time. The Sep 25 date cashes it in. Think he makes it back with paperwork and a clean screen?
People are going to disagree, sir. They're part of the reason we're here is because people disagree. And I have to make a decision, but it has nothing to do with anybody personally. For me, doesn't have to do with any of that.
But the actions of Attorney Magnus did have very real consequences for me over the last several months since his involvement. I mean, mainly with the Farmington Hills house and with his changing his mind about the sale of the farm and trying to get the farm sold rather than have me be able to buy it. So he has made arbitrary decisions, him and Timothy Flynn, which have
They
very much.
can be as arbitrary as they want. As client, they can be as arbitrary as they want.
I would argue not. I would argue that the law.
Okay, you can argue that. I'm telling you, they can be arbitrary regarding certain things that they want to do. They don't have to operate on your moral guidelines.
Well, the law is very clear that they're supposed to be impartial and not do things that benefit the favor one devicee over another.
Then that you need to take up with the probate court if you believe that that's happened.
I absolutely believe it's happening, and I absolutely am taking it up, and that's part of the reason.
Okay, then that's where that argument belongs.
That's part of the reason I need more time here, because all of this helps to speed along what should have been more deliberately handled in the probate court.
Anything else?
What remedy is there for the harm that's been done by Attorney Magnus having my vehicles towed and that was only because of the August 21st order that you signed when Attorney Magnus implied that he was continuing, we've discussed. What remedy is there for the harm that I suffered? And there is a harm to the.
What kind of vehicles were these?
It's a 2002 Pontiac Grand Prix that was functional. It needed a new fuel line. That's
A 2002 Pontiac Grand Prix.
yeah, I mean, it's not worth much.
The other car. What's the other
I've
vehicle?
submitted pictures, Your Honor, of the vehicles when we killed them.
The other car is a 1990 Honda Civic, which is actually worth more than the Grand Prix, even though it's not functional.
Yeah, that's people judging what American cars are worth. Go ahead.
Well, it's because there's some like people, fans of a movie, people like this old model Honda hatchback, and the engine in my Honda Civic has only 100,000 miles on it, and there's other parts. So I've seen ones that are just like a shell for 1,000 or more. So my car with significant parts was worth over $1,000, the Civic. And
Okay, so it's $1,000. And then how much is the other one worth? It's a GM, so it's not much. I'm a Ford guy.
the other one was worth between 500 and 750, whereas scrap value.
So we're talking $1,500.
I would say the Civic is actually worth more than 1,000. I said 1,000 for a.
How much are you saying?
$2,000.
2,000 total. All right. Anything else?
Heads up! A probable cause conference, PCC, is the huddle before the big play. Lawyers trade discovery, float offers, and decide if a prelim is worth it. Adjournments here are installing their strategy. Would you push forward fast or buy time to sharpen leverage?
Briefly, we're the most recent.
You may take whatever time you want. You have been very patient and listening. Go ahead, sir.
I won't take long. You and I think see the same case the exact same way. I'll just say we're the latest in a long line of judges and attorneys engaged with Mr. Samuels in the exact same way. We have, I think, 7 other eviction cases. There's 9 appeals, maybe 10 pending Court of Appeals with regard to, this goes back many years. The point being, I did put the court in this position by missing that 56-day court rule.
And can I just stop you there? Because, and I think it's important to point out, as this gentleman has been sort of smearing you, one of the things, and I remarked it to my staff when I went back, and that is that you came in, and for somebody that's looking to hide stuff or do whatever, the shady stuff he says you're doing, you stood before this court, said, look, Judge, I wasn't aware of this. I did this. This is what I did. Just straight out. And I'm going to just tell you this, Judge, I appreciated that. That's how lawyers practice. Go ahead, sir.
Thank you. Yeah, so like I said, at the last hearing, I learned that one in real time, right? So we could have had this hearing 2 weeks earlier. But as you said, the result's the same. Mr. Samuels doesn't live there. We removed his cars. Yes, they're waiting at the impound for him to pick up. No problem. And I just asked the court issue the order so we can move this whole process forward.
All right.
Yeah, they want a lot of money to pick them up, so that's, and it's, I have another property a mile away that if he worked with me, we could have put my cars at my other property a mile away. Now they're somewhere 20 miles away, and it's.
Or if they were drivable prior to this happening, you could have moved them there.
Yeah, they weren't drivable. The driveway needed to
Okay,
be a
then you
mile.
could have gotten a tow and got them there.
Exactly, a mile would have been an easy, cheap tow, but Attorney Mondes didn't work with me, didn't contact me.
You know, I just hook
And,
into my truck and drag it up. I'm kidding. Go ahead.
well, no, I actually could have done that. To take him down.
So why is that his fault?
Because he didn't let me know that he was.
Because
leaving.
everything is his fault.
There was no reason for me to think that he would tow the cars in August.
Okay.
There was no reason for him to have done that without notifying me. He gave me no notification at all, and he was notifying me of other things. He refers to evictions and all. The bottom line is that when I was conservator, I did for my family what anyone would want a conservator to do. And I was only removed as conservator 2.5 years ago because other attorneys said things in court, material facts that are absolutely not true, that the judge even acknowledged when seeing video.
Oh, so these were other lawyers that lied?
No, it's again, my sister's lawyer is the main.
Oh, okay. All right. I'm just trying to get it clear.
Well, my sister's lawyer has misrepresented material facts many times.
Okay. There we go again.
She has.
Okay.
Can prove.
Okay, that's fine. Is that before me?
Attorney
Is it
Montes
before
just
me?
went through all these
Is it
issues.
before me?
In a way, it is.
Why is it before me?
Consequences of it are before you. All of this has happened because from the beginning, I did what anyone would want as conservator. And instead of it being applauded, I markedly increased my parents' wealth. I did everything the way Dad wanted. I cleaned up their house such that the judge, seeing the video, said, yes, it does look good. But the attorneys for other sides said, I didn't do what I did, even though they had video, a proof, and later acknowledged that I did what I said I'd done, but they hadn't believed me. So it is before you because the consequences of everything that's gone on in the last 4 years lead us to where we are. So this is just the final action in a terrible sequence of events, which started with my sister betraying my parents when they were clear on what they wanted for the future. And both my parents died prematurely without me caring for them because of the probate court involved. And It's obviously sounds crazy, but it is.
No, it just sounds like another one of your attacks on somebody else. That's what it sounds like to me.
So when Dad was saying he wanted me to keep caring for him and I was having him gain weight and they took him away from me, it's my.
Sir, then all of that has nothing to do with this case.
Indirectly, it does, because it led us to where we are. It's like there should be, my dad's will said the PR would be my sister and me. We only have an independent PR because of actions by my sister's lawyer 2.5 years ago that I didn't even understand.
Then you need to bring that to the probate court. I can't do anything about that. Even if, for whatever reason, I thought you were right, and I have my serious doubts as to whether or not you are. Even if I had my doubts, there's nothing I can do.
Well, you could just do nothing rather than enter the order of eviction.
You haven't been here before. It's rare I do nothing.
Well, in a case where there's some question as to,
No, I really don't have a question.
there are some appellate cases relating to the district court's involvement in the estates and landlord-tenant issue.
If you believe that my action is inappropriate, sir, you have all of your appellate rights.
I'm already completely overwhelmed with what I'm trying to do.
Whether or not you choose to exercise those rights is beyond me. But you will have them.
I just,
And unless there's anything else, I'm ready to rule.
I understand that, and I just think that, you're, as with everyone, respecting the lawyers instead of analyzing actions that they've done. Like,
Sir, you know what? I'm gonna stand in here at recess. I will come back. I promise you I will come back, but I don't want to say anything that's gonna get me in a whole bunch of trouble.
All right.
Ms. Weidling?
Help me, Your Honor.
You see.